Yes.
All right. I think we're ready.
Okay, I have, we've gone live, so we're just gonna maybe give it a minute or two for people to start rolling and then we can get started.
Sounds great. Seems like the weather has finally caught up with the calendar. I think I heard it was supposed to be 91 degrees today. Can't wait till we get a day where it's 98 degrees so that I can, in true dad joke fashion, break out some old CDs for my wife. Mike, thank you for getting that joke. I appreciate it. Yeah, it was pretty bottom of the dad joke barrel there.
Okay, well, it's 11:32 and we have several people that have hopped on. So if you guys are ready, we can go ahead and get started.
Yeah, no, that sounds great. Well, hey, thank you everyone for being here today. My name is Sam Foreman. My colleague is Mike McPhee. Mike is a very fine attorney, focuses his practice on business law as well as some intellectual property issues such as technology licensing and trademarks. Mike is one of the world's finer athletes in the semi-professional hockey ranks. He's far too modest to admit it, but he's a very good hockey player. I was a bench warmer on very small school athletic functions growing up. So someday I hope to be as good at some athletic event as Mike is at hockey. My practice focuses on business and transactional law. I work with a lot of small businesses, helping them set up, in particular, helping them set up their ownership structures and navigate some of those issues. So we're excited to talk to you all today. We try to have a very interactive style. So if you've got questions as we go along, please feel free to raise your hand and ask those questions, and we'll try to have Mindy field those as we're going along and respond to those in real-time fashion. We also have a Q&A session at the end, but certainly don't feel like you've got to save those questions to the very end. And if there's anything we don't cover that you'd like more information on, certainly feel free to ask us that in the Q&A session or as it becomes relevant throughout. So. And thank you all for carving time out of your busy schedules to join us. Hope you enjoy the presentation and that this is useful information for you. First off, a disclaimer, this presentation is for informational purposes only and is not intended as legal advice. No attorney-client relationship is formed by this presentation. Some questions that we get occasionally during presentations will be a little bit too specific for us to answer without complying with our ethics rules here on a presentation like this. We'll do our best to answer and provide useful information to the extent we can. And if it's something we don't feel comfortable answering here, we'll just flag it for you, and our contact information is at the end. You're welcome to give us a quick call or email, and we'll try to help you out that way as well. So in terms of what we're trying to cover today, we want to talk really about getting into business and getting out of business with co-owners. We're going to cover a couple of topics. Most of this is going to be focused on, getting into business and structuring, ownership relationships. But we're also going to talk about what can often become a very painful topic for folks, which is getting out of business. So in terms of getting into business, we want to talk about what are some of the things you really need to think about when you're getting started. What are some monetary, financial, tax terms you need to be thinking about? What are some ownership things you need to be thinking about? Management, structure, decision-making rights. What about, how do you protect the team when it comes to what kind of activities people can engage in outside of their ownership in the entity? And then we'll also talk about transfers and transfer restrictions, which as some folks find are really important terms. And then lastly, we'll spend a little bit of time talking about what can sometimes become the most important topic in your life, which is, okay, this isn't working out. How do I get out of business with this person? So, or these group of people. So getting into business, let's talk about getting started. I think the first thing you want to think about when you're structuring ownership relationships with folks is to think about what your business actually needs. I've seen folks go into business together where they come to us and it's like, hey, here's who all's involved and here's what everybody's ownership percentage is. And we talk through it and we start talking about what everybody's bringing to the table. And then it becomes clear that there's some people that are taking up, maybe they're 25% owners and they haven't brought money and they're not bringing services and they're just kind of there and they're not really doing anything. And so I think it's really important as you get started to really think about what does your business actually need, and use that as part of structuring, your business and how it comes together. Sorry, give me just a second here. Then think about everyone's commitments to the business. Think about, is it, when it comes to money that people are going to put in, when it comes to services that they're going to put in, the amount of time it's going to take, all of that stuff. What is everybody actually committing to the business? And then how is that documented so that it's clear what everybody is really in for? So that everyone can have a lot of confidence that things are headed in the right direction here. So and that their expectations are clearly aligned, and so on. Give me just a second. Sorry, just a moment, folks. I've got just a really brief interruption. You also want to take time thinking about what could go wrong and also what could go right. That'll make more sense as we talk through a number of the related topics as we get into some of the more nitty gritty on some things. But you want to think about what can go wrong, what you care about going wrong, whether that's, okay, one of my co-owners has some extended family health issues, and what happens if they need to go spend a lot more time on that instead of on the business? How are we going to handle that? What happens if they decide they want to go back to school and now they're not available to work in the business? And then think about what happens if it goes right. The business is wildly successful and now we want to sell, or now we need to bring in additional owners so that we can bring in additional money and really grow things at a more rapid pace. And then you want to think about picking an entity type and a structure, whether that's a limited liability company or an LLC, whether that's a corporation or some other structure. One distinction I want to make sure everyone is really clear about here is that, a lot of times we'll hear people say, well, I'm structured as a sole proprietorship. Well, a sole proprietorship means that there is no legal entity involved. And so as a result, there's not really any limited liability protection. And so if you're trying to structure your business as a sole proprietorship, just please be aware that that's not something that really actually provides you any personal limited liability protection. And if you've got co-owners involved and no legal entity involved, you've probably got what's called a common law partnership, which can create a whole host of other issues. We won't be covering either of those in any detail here. Most of this presentation is going to be focused on talking about some things that are most common in the limited liability company setting or the LLC setting, but a lot of these terms and concepts apply equally to a number of other entity structures. And lastly, as you get ready to get into business with somebody, you really want to think about the end at the beginning. How are we going to unwind this thing? How are we going to get out of business together? And how are we going to, well, let me put it this way. A lot of people describe it, because it's fairly accurate, that being a co-owner of a business with somebody is very much like being married to them. And thinking about the end or the exit at the beginning is like having a prenuptial and planning the divorce at the beginning of the marriage. and you want it to go smoothly, you want it to work well, you know, you want to have reasonable protections in place and not get stuck wondering, well, how are we going to figure this out? Because certainly you can't account for everything, and but it's a good idea to try to take reasonable steps up front. Let's talk about some of the monetary terms. So whether it's a capital contribution into an LLC or a investment into a corporation, you want to make sure that there's clarity around what is everyone actually putting in. And is that documented, and is it clear here's what everyone's putting in exchange for their ownership piece, so that things are handled properly. You also want to think about what are the services that everyone's bringing to the table. You know, you may or may not be surprised at the number of folks that will get started with a business and not really have any kind of clearly defined or written terms around what everybody is going to be doing. And so as a result, you can end up in some scenarios where somebody owns a piece of a company that they haven't really put any money into, aren't really obligated to do anything with. And so you want to be really careful about how that's addressed, so that there's a fair way to make appropriate adjustments so that folks that are continuing to put in money and services are properly taken care of, relative to folks that aren't, for whatever reason. And so that it's just clear, because, well, a colleague of mine used to describe it this way: honorable people will do honorable things. And if you put out really clear expectations on things, you tend to get a better result out of that process. Some related concepts to defining those services is, and those expectations, is describing, are people going to be getting paid a salary for that? Under an LLC, are they going to be getting a guaranteed payment or some other form of compensation? What is it that they're going to be getting, and how do we have that structured so that it's clear, I'm doing X, I'm getting Y, you know, here's my obligation, and here's the benefit I'm going to receive as a result. Related to that, you may want to think about what are capital calls look like, or what is the if we were all in a room together, I'd say, by show of hands, who knows what a capital call is? Some of you have probably received a capital call before. What it is when the company needs more money, the company will sometimes have the ability to require the owners to put in additional money. I don't typically like that structure unless that's been negotiated heavily in advance, to where people are really clear, this is what I'm going to have to put in if the company needs additional money. I much more prefer having it be optional, or just not be something that has to get addressed at all. But where it can be helpful to address it is to just lay out a process that says, hey, here's what we're going to do if we need more money. If people put in, you know, additional money, they get additional ownership. Here's how that works. Here's how we determine what it is, and so on and so forth. But you want to be really careful if you're going into business about whether or not there's a mandatory capital call, so that you know whether or not you're going to have to fulfill on some financial obligation to the business at some point. Also be thinking about tax status and tax elections. You know, is it going to be an S Corp? Is it going to be just taxed as a partnership? If it's an LLC, is it, you know, are there other elections that the company is going to make that are important to keep track of that need to be negotiated in advance? That's really something to talk with a good tax advisor, a good CPA about as you get into it. You want to think about whether or not there are mandatory tax distributions, and whether or not there are any kind of mandatory or discretionary profit distributions. Where you see some minority owners get into trouble is if the business is making money but is not giving them anything that they can use to pay their taxes with. On an LLC, that's taxed as a partnership or an S Corp, the individual owners have the obligation to pay their pro rata portion of taxes based on the entity's income. And so if, you know, if somebody has, you know, $100,000 worth of income that is attributed to them, but they don't have a tax distribution from the company or distribution to pay their taxes from the company, they can end up in a situation where, sorry, can you hand me that mic? They can end up in a situation where, they have a tax bill that they can't really take care of because they're not getting money out of the company, and that can be very painful. And every now and then you'll see majority owners try to abuse that because they may be in a position to decide whether or not the company makes those tax distributions, and they can sometimes use it to squeeze out or just try to get rid of minority owners that they just don't really like for whatever reason. And so you want to be really careful about those. On profit distributions, you also want to have some expectations set around that. It's pretty common to have those structured to where, we're not paying distributions unless everybody agrees or unless a majority agrees or some other function like that. We just don't want to be in a position where we have to kick out money if the money needs to get used to keep growing the business. But you want to be clear on, again, what is the expectation, what could happen, what rights might the company have, what rights do the owners have to profit, so that it's just clear what the expectation is. Because you don't want to go into it and then find out that somebody else is really upset because they were expecting that they were going to make all this money and that it was going to continue to get distributed out, when in reality the business plan is, we're going to make a bunch of money, but it's not now, it's going to be a couple years down the road, and we're going to put everything back in the meantime. Any questions so far, folks?
I don't see any questions so far.
Great. I'm going to keep cranking along. Let's talk about a super important topic. Let's talk about ownership. You want to think about ownership percentages. Think about how much of the company does each person own, and making sure that that's clearly documented. Related to that, I should have had another bullet point on here. You want to think about whether or not there are multiple classes of ownership and whether or not those classes have different rights. With an LLC, for example, and of course there's lots of legal and tax nuance to things that you'll need to be aware of that's beyond the scope of this presentation. You can get as creative, just about as creative as you want. And you could end up with, Class A, for example, having different voting rights than Class B, or Class B having a priority in terms of when they get their investment back versus Class A. And just a lot of different, options there. I mean, same with a corporation, you could have similar type of structuring. What you want to be aware of when you're thinking about multiple classes of ownership and the different rights that might apply to some of those classes is that if you choose to be taxed as an S corporation, which an LLC can be taxed as an S corporation, a traditional corporation can be taxed as an S corporation, that you can only really have one class of ownership interests. And there's even some nuance to that, that a tax advisor can go into more detail with you, or we could certainly. But you want to be aware that if you try to get too creative with classes in a S Corp, you might unintentionally cancel your S corporation election, which could have some tax ramifications there that you don't want to have. You want to think about voting and profit rights. Is it clear that, for example, if it's one class, then everybody should have the same rights relative to their ownership? If it's multiple classes, that might be defined differently to where, one class has different voting rights and different profit rights than others, as I've mentioned. You want to think about how does it work when we decide that it's time to add owners? Or in this case, with an LLC, to add members to the LLC. Is it something where we have a majority vote? Is it more than a majority that's required? Is it unanimous? Is it just something that whoever's running the company at that time has the ability to determine and set those rights? How does that process look and work? Related to that is something called preemptive rights. And what preemptive rights are typically is the right for somebody, and it needs to be spelled out in some form of contract typically. is the right for somebody who's an owner to be able to maintain their ownership percentage by continuing to buy ownership from the company when it decides to issue new ownership. So for example, if I'm a 10% owner and the company decides it's going to go sell $100,000 worth of stock, I might have the right to maintain my 10% ownership by buying 10% of that $100,000. So, putting in another 10 grand in that case, so that I can stay at 10%. And so you'll see that sometimes, without that kind of a term, typically your ownership is going to get diluted when additional members are brought into the company. And it'll end up with, just kind of going down based on what's been sold to those owners, those new investors, or it could be existing investors, depending on where the money comes from. Then you want to think about what's called dilution protection and whether or not that makes any sense in the business. Dilution protection is fairly uncommon, but what it does is it allows someone to just, under whatever circumstances are defined, to maintain their ownership percentage regardless of what happens with new owners and new investment into the company. And what that effectively does is it means that everybody else gets more dilution, that their ownership percentage goes down more than it would have otherwise based on that limited dilution or that complete dilution protection. Any questions on that so far? I don't think I see any hands up. Great. Y'all must be tracking really well, which is good. Next, let's talk about how the management of the business is structured. There can be a lot of different ways to structure things, but what you really want to ask yourself is, as Clint Eastwood says, do you feel lucky? Depending on how many controls you have in place and whether or not you're a majority owner, 50-50, or a minority owner. So directors are, if there's a board on the entity, a board of directors or a board of managers, that group may have the right to make certain decisions without consulting with the other owners, just depending on how things are structured. And you could have a board of directors in a C corporation or an S corp. You could have it with an LLC. You could have a board of managers on an LLC. You wouldn't really have a board of managers on a C corporation or other corporation. Below, so the directors are typically at the top. Then below the directors are often the officers that the directors elect or appoint. So that'd be, if it's a LLC, that could be a manager, it could be a CEO, could be a president, could be vice presidents, treasurers, secretaries, etc. Whoever's going to be charged with running the company. Those folks will often have clearly defined day-to-day authority. They may have, specific authority that they've got to make certain decisions, etc. With an LLC, you'll often have it be managed by a manager or by a group of managers. That role would typically be very similar in authority to a president or a CEO of a corporation. Although, of course, you could have a president or CEO of an LLC as well. You can get pretty creative with things. The manager will often have kind of day-to-day authority that's defined in what's called an operating agreement for the LLC. There's really two different kinds of management structures for LLCs, or at least two that are most common. One is manager managed, where you've got a manager or a group of managers that have the authority to make decisions for the company in most cases, or you might have member managed. I typically like manager managed so that there's a clear line of decision-making authority on most day-to-day decisions, and it gives third parties a better, more clear understanding of who has the ability to sign things, to take certain actions, etc. Member managed, to me, can get a little bit messy, particularly if you have a larger group of members and there's more need to spell out who can do what the process is, and so on and so forth. A lot of times you'll see in an operating agreement, it say, the manager has day-to-day authority, and then a list of things that they cannot do, such as, which is really what the next bullet point is about, is limitations on authority. And so thinking about things like what types of transactions can the manager enter into without going and consulting with the other owners and getting authority, assuming that the manager is either not an owner or is is a minority owner. Thinking about how big the transactions are that they can be, going out and executing on by themselves. So for example, is it a single transaction limit of $10,000, $50,000, et cetera? Is it a series of transactions within 12 months that are related that accumulate to $50,000? How is that defined? Can they settle litigation on their own? Is it up to a certain dollar amount? Can they sell the company's assets outside of the ordinary course of business? What are those things that they cannot do that without getting approval from everyone else? And so thinking through, what does that process look like? What are the things we really care about? And that kind of goes back to one of our earlier slides of thinking through, what are the things that you're worried about might go wrong, that you want to make sure that there's good process in place or good legal rights in place to kind of try to take care of everything. Then you want to think about the delegation of authority. A lot of times, especially as the business grows, it's not going to make sense that you have a bottleneck where, one person is trying to do everything. And so trying to think through, is there a process in place, or are there legal rights in place for, the manager of the business, for example, or the president or the CEO or the board, to appropriately delegate authority to others to take action on behalf of the company? And how is that parsed out and controlled appropriately so that things run smoothly and everyone has clear expectations on things. So go on to the next slide here. Actually, I'm going to pass this to Mike. And Mike's going to talk about some of these key terms that can be really helpful in not only setting expectations with everyone that is on the team, but also helping to protect the team, protect the business from, a variety of different things. So Mike, I'm going to mute over on this side and let you.
All right, so, okay. Awesome. All right, so non-competes. Non-competes are going to limit what the team or the members can do outside of the business's activities. So generally, these are going to say the members can't engage in the same or similar business for another entity or business. This is going to protect your business by, limiting what they can do, and they won't be able to directly compete while they're also members of your business. There's a variety of issues in terms of enforceability of these. Non-competes generally have a durational aspect to them as well as a geographic scope, and in all cases they have to be reasonable in order to be enforceable. Durations that are too long aren't going to be reasonable, such as a 10-year non-compete. That would be a little bit too much. Outside of sorry, Sam, do you want to speak to that at all?
Yeah, no, absolutely. So there's a couple examples of non-competes that are typically enforceable. They're very setting specific, and so you really want to be careful with how these are done. But Kansas law, at least, will often enforce up to a 2-year non-compete in a reasonable territory if you've got somebody who's important to the business, has access to key information, is providing valuable services to the business. There's a number of justifiable basis for it. the employment context, I think courts are a little bit less likely to enforce a non-compete, although they can often still be enforceable. When you've got a co-ownership relationship, I think they're generally a little bit more willing to enforce that, but it's very fact specific, and so you want to be careful about how these are structured. And if it's something where, let me use an example, we form a business to buy one piece of real estate, and we're going to flip a house, that's probably not something where a non-compete is reasonable or helpful or going to be enforceable. But if we're doing something, we're starting a new kind of business, we're doing something where people are going to have access to really sensitive information, they're heavily involved in it, and if they left, it'd be very damaging, and did something competitive, it'd be very damaging to the business. That could be a much better basis for enforceability. So just a lot of things you want to think through. You also want to think through, what is the interest you're trying to protect? How broad in terms of geography is it? Is it just, hey, we've got a market territory here in Wichita? If you say, hey, continental United States, that's probably not going to be enforced, and it probably doesn't help you a whole lot. But so just think about, what are you trying to protect? What's reasonable? And then maybe thinking about building in some flexibility, which you can do sometimes, to help to have that that provision sort of grow as the company grows, so that to the extent there's a expanding reasonable basis, we're now in Kansas City and Wichita, or now we're out throughout the entire state, and parts of Missouri and Iowa and Nebraska and Oklahoma. How do we make sure that remains protective and reasonable at the same time? So.
So non-solicitations generally apply when the individual is trying to either solicit customers away or employees away. In terms of members of existing members of the company, perhaps they have an ownership interest in another business. This was sort of protects, them quote unquote stealing employees or customers away from the business that you're in with them. This also applies to when they exit the business and they can't, bring along employees, customers, etc. Non-disparagement essentially means, they can't speak ill of the company. Sam, do you want to expand on the non-disparagement piece?
Yeah, absolutely. So defamation might be a term that y'all are familiar with, and from a legal standpoint, prevents somebody from going out and lying about your business in a way that's damaging to your business. Defamation claims from a legal perspective are really hard to prove, and they can be very expensive, and most lawyers think that they're losers of legal claims because frequently you have to prove damages in addition to proving falsehood or a lie has been made in order to be able to have any kind of legal recovery. And so you might have a really good belief that somebody has damaged the business by something they've said, but a really hard time proving it. And at the end of the day, just spending a bunch of money trying to make lawyers, a bunch of money and not getting a lot for the business. What non-disparagement is intended to do is to make it easier for the company to protect itself, again, by setting a good expectation up front that, hey, we're not really interested in whether or not the statement is true, and we're not really interested in whether or not the statement causes damage. All we're looking at is the contract to say, for example, was this statement in public, and was it negative about the company? And if, assuming it was that simple, if those two elements are met, then you've breached your non-disparagement and we're going to have a claim against you. You still might have issues with damages or any number of other legal things, but the goal is to set a good expectation that the company's reputation and goodwill is really valuable, and we're not going to go out bad-mouthing the company in public. We're going to keep our mouths shut and our thoughts to ourselves. so that, the company can protect itself a little bit better. So.
And then non-disclosure, confidentiality. These are meant to protect confidential information of your company. And this expands to not only work products, but also, conversations internally, business opportunities, and a whole variety of other things, trade secrets, as well as other IP that isn't necessarily ready to be made public yet. Yeah.
One thing that you want to really be mindful of, and all owners in a business should really be aware of, is you want to set good expectations, and you want to have reasonable protections in place. And so if you've got, if you are, or you've got someone that is, trying to be an owner in multiple related businesses, or that's part of their plan, and they need to keep options open and different things like that, you really want to be thinking about whether or not these types of provisions are going to make it too difficult for that person to be involved or a valuable part, or do you need to provide some sort of carve-outs for that person? Even where these terms aren't involved, people can still run into some issues with, do they owe a duty, or do they have an obligation of loyalty to the company that would prevent some of these things? And so what you'll frequently see is a provision that tries to say, hey, listen, if we haven't said you can't do something, then you can go do whatever you want. And that tries to keep options open for folks. So just be mindful of those kind of things. So go on to the next slide here. Transfers and transfer restrictions. Man, is this a fun topic. I hope you all are ready and excited. Let me talk about why transfer restrictions are important. For most small businesses, when you're going into business with somebody, you're going into business with that person. You're going into business with them because you like them, you trust them, they bring something unique, valuable, special to what you're trying to build. If you don't have a transfer restriction in place, they might be able to go out and sell their ownership to somebody else. And then you might be surprised one day when you get a phone call or an email from somebody you don't know or you didn't plan on being in business with, saying, hey, let's talk about what's next for the business. I'd like to look at the books. I'd like to, come talk about what's next. And so you want to have those kind of protections in place. The way I like to think about it is, you've got a specific set of folks at the table that you're going into business with, and a good set of transfer restrictions can provide reasonable protections to limit who's an owner to the people at that table. You also want to think about, and so some customary restrictions would be just a blanket restriction, starting with a blanket restriction that just says, hey, unless we've specifically said you can make a transfer here in our company documents, then you can't make any kind of transfers. Sometimes you'll see a carve out, and sometimes this can be really reasonable, and sometimes it's just, it's just a little bit too much depending on the nature of the business. Sometimes you'll see rights to transfer to other owners. Again, that helps keep things at the table, or to transfer it to the company. There's a number of issues that are kind of beyond the scope of this presentation that probably need to be thought through on that. You can also have carve-outs that allow transfers to third parties. So somebody comes to me and says, hey, Sam, I want to buy your ownership in the Dallas Mavericks. I don't actually own part of the Dallas Mavericks. I wish I did. That'd be pretty cool. Then what will often trigger is a obligation for the person receiving that offer, assuming that they decide, man, that is a good offer, I want to go take that, to go to the other owners and say, hey, here's how, or here's the offer I received. And then it'll have a process spelled out in the documents to say, here's your opportunity to buy my ownership up. Sometimes it'll say you can buy your pro rata piece. Sometimes it'll say you have to buy all of it or nothing. There's, multiple right or wrong ways to do that depending on your perspective and the circumstances. And then, typically whatever's not purchased in that process could be transferred to that third party. What that does is it provides a little bit more liquidity to folks to be able to sell their ownership, to be able to get out of their ownership if they've got a good opportunity, but also balancing that with the need for the other folks that are involved to really just stay in a good spot with their, being able to control it and keep things at the same table. However, I do want to make this point. What you really want to think through in terms of whether or not that's a term that you all want to have as part of your business is realistically, what is the ability of the other owners in the company to be able to actually exercise that right of first refusal? A lot of times early on in the company's development, everybody's money is tied up in the value of the business. And so, and it may not be something where the business is to the point where you can go to a bank and say, hey, somebody wants to buy out, Joe over there for $500,000. How can we raise that money to buy her out? And so you really want to be careful thinking about, is this something we want to add later? Is this something where we want to put some kind of trigger on it that, hey, we've got to get down the road at least 3 years before people can do this, so that you really think that through. And then lastly, one of the customary, I guess, transfer permissions that's allowed is transfers for estate planning. So somebody wants to put their ownership in a trust so that they can get some tax benefits or kind of line things up appropriately. Frequently, you'll see that permitted, and we generally try to allow that. And you also want to see something that says, hey, here's what happens if that person that we're actually dealing with either isn't involved anymore or dies or what have you. We want to have some sort of process, or at least think about whether it's appropriate to have some sort of process for the business or the other owners to buy out that ownership, or at least to take away voting rights, so that you don't have to deal with someone's grandkids from Scottsdale, assuming that you don't like the grandkids from Scottsdale or whatever else. So give me just a second here. Move on. All right. Any questions so far as we're going along? Great. Seeing none, I'm going to push forward. Let's talk about getting out of business. This can be really important, particularly if you're a minority owner and you don't have the ability to make control decisions for the business. You really want to think about, how am I, and it's also important if you're a majority owner for a number of the same reasons, thinking through what happens if our relationship isn't working out, the business isn't working out, or maybe things are going great. How do we have clear processes in place that create some predictability for us as we're going along? Because you don't want to end up in a position where you don't have any kind of exit except for one that requires you to either go in front of a judge or try to work out something with someone who you may not be getting along with at that point in time. Because those processes can just drive the costs way up. They create a lot of stress and tension and pressure for everyone involved. So here's some ways to get out of business with people. Have just unfortunately recently had a client who had to use option number one. Didn't have in their company documents a clear path out of business. And we're 50-50 owners in that business. And so had to go, the legal route to, go to the court and say, hey, this isn't working out. It's time to wrap this thing up. We can't get them to agree with us on, the right set of things. And they've got to go through that whole process. It's not fun. It's messy and create a lot of other legal issues. And so trying to line yourself up and be in a position to avoid that is really important. You can't always get to that point where you can force a court, or you can use a court to force somebody to let you out of the business. There's certain legal requirements that have to be followed, and typically there's got to be some kind of gridlock where the company can't actually continue making decisions without that kind of a court order. And so, you know, if the company can actually continue to make decisions, courts may be fairly reluctant to allow any kind of, you know, breakup of the business. They'll typically try to say, well, hey, you made this deal, you know, you're just kind of stuck with it. You can also have negotiated buyouts, where one of the owners goes to the other one and says, hey, this isn't working out. Let's figure out how we're going to break this up. You know, make me an offer, or hey, here's an offer to buy you out, or an offer that I'll sell to you at, and so on and so forth. So those, you know, don't create any kind of predictability or certainty until there's actually a deal that's been agreed to. Because until the deal's been agreed to, everybody's just kind of continuing as they are and still trying to, you know, put things together to make that kind of a deal work. And if you've got somebody who just really doesn't want to do the deal, you can have somebody having to take a real haircut on the price and the value of their ownership. Next is kind of buy-sell agreements. I mean, this is really something that has to be negotiated and entered into ideally at the beginning of the business relationship. And with an LLC, you'll often see this type of a term, you know, tied into the entity, into the company documents themselves. This is something where it's really important, I think, to really try to have this addressed, or at least discussed at the beginning, as far as whether or not this is something that's important, at least when there's a 50-50 ownership structure. Because if there's a 50-50 ownership structure, you'll typically have, you know, the ability, or you'll have the potential for gridlock, where people just can't get along, and then the company can't make decisions, and then, you know, everybody's value that they've got tied up in the business is really in jeopardy because there's just, you know, there's no decisions made there until, you know, your 50-50 owners can agree on stuff. So a lot of times you'll see a buy-sell that has a predetermined price or predetermined formula. Those can get fairly complex. Those may be appropriate in certain circumstances. You want to be really, really thoughtful about how that process works, when it can be triggered, and how that price is set. What I like a lot of times is, you know, assuming that the parties involved have relatively equal footing, is a provision where somebody can, and it's often called a shotgun buy-sell or a shootout provision, where one member can go to, or one owner can go to another owner and say, hey, I'll buy you out for, you know, this many dollars a unit, or this many dollars a share. And then that person who receives that offer has a certain amount of time to think about it, and they could go, that is a good price. I'll buy you out at that price, which helps to create both some economic efficiency, that we don't necessarily have to go use an appraisal process and incur those expenses. We don't necessarily have to go through, you know, a bunch of accounting records to figure out what a particular formula says that the purchase price ought to be. But we have some accountability in the process, in the sense that somebody who initiates that process really needs to make sure that they're putting forth a fair offer, because they know when they start that process that whoever they're making that offer to could turn around and say, no, guess what, I'm going to buy you out. And so they've got to be prepared for that, and that'll typically, you know, create enough accountability to avoid some problems there. Next, you want to really think about having a permitted sale to a third party. This is, you know, something we talked about earlier in that right of first refusal process. But this can create the ability for somebody to get out of the business, you know, sell their ownership, have some, be able to get something for their ownership piece, and not have to stick around, but still while putting the other owners in a position to protect, or limit who's at the actual ownership table. So this is a good one to at least think about whether or not it makes sense to have in there. I think we talked about earlier it being a right of first refusal and what that is. Sometimes it's structured as a right of first offer. And a right of first offer is not nearly as strong as a right of first refusal. The right of first refusal says, hey, you came to me and you told me you were going to sell to so-and-so for $10 a share. I'm going to buy you out at $10 a share. Right of first offers functions for you just to come and say, hey, and this is of course very fact and language specific. So this is just a really broad generality. Please keep that in mind. Please keep in mind that the whole presentation is broad generalities. We could spend hours talking about any one of these topics, although I don't think anybody probably wants to listen to us talk about any single topic here for that long. Right of first offer is typically a right for somebody in the circumstance where an owner says, gee, I want to sell. I'm going to go sell. I've got to provide notice to everybody else. Hey, I want to sell. And then everybody else has an opportunity to come say, hey, here's my offer. Will you sell it to me for this? And then that person can decide whether or not to sell. If it's just the right to make an offer, that doesn't necessarily create a right to sell. Sometimes it could be structured so that, hey, if I provided you the best offer, then you must sell to me. There's just a lot of different ways to structure these things, and they can be as creative as you want to be. Let's talk about tag along and drag along rights. So tag along rights, this really comes to the sale of the business as a whole, or something that's structured similarly to the sale of the business as a whole. And what a tag along right is intended to do is when the majority says, hey, we're ready to sell the business. It's going to be an asset sale. It's going to be a stock sale, whatever it's going to be. This is what we're going to do. The tag along right says, okay, the majority, you've got the right to sell. Tag along says, hey, I'm the minority. I get to tag along in the sale. You have to take me with you. Don't leave me with these people. You got to take me with you at the same price, at least at the same price per share or same price per unit, so that I'm able to get out when you get out. And for a minority owner, this can be a really valuable protection, as well as being a good way to think about getting out of the business. The drag along right is sort of the inverse of that, and it's intended for the majority to exercise. The majority will have often the right to sell, their ownership or to require the sale of the whole company to a buyer. Again, you want to see in there the right or the protection that that the minority gets the same price per unit. You'll often see carve-outs in there that says, hey, if I'm selling to a buyer and the buyer says, hey, Sam, I want you to stick around. I want you to work for me for a couple of years, and I'm going to pay you, this, that, and the other thing. You'll frequently see some language that says, hey, it's just limited. The price that I've got to get for you is just limited to what the buyer's actually paying for the actual stock or LLC ownership interests. It doesn't extend to what the buyer pays somebody to stay on as an employee or a contractor or whatever else. And so you want to be sensitive to those provisions. You also want to think about withdrawal and other contractual rights. There's often the way these agreements and documents are structured, there's not a right for somebody to just say, hey, I'm done, I'm out. Sometimes there is, but frequently there's not. And so it's important to think about, how do you have that structured? What actually happens when somebody's ready to get out? If they don't have one of these other abilities to get out, is there a way you can structure it for somebody to just say, hey, listen, guys, I'm done. You can have my ownership back, or hey, you've got to buy me out, but I'm out. And so you want to think about that. Another thing that is related to this and relates to getting out of business with somebody are what I generally will call purchase options or obligations. And so sometimes what you'll see is that one owner, and I probably could have broken this up into multiple points a little better, but one owner will have a right to buy out another owner, or perhaps even several other owners, at a certain price or under certain circumstances. And they'll just have that right to do that. And sometimes you'll have certain triggering events on involuntary transfers. So for example, if someone dies, what happens to their ownership? You want to see something that tries to address that, or at least be aware that it's unaddressed. What that could allow is a process, if it's spelled out appropriately, for the other owners in the company to buy out the ownership and pay, the estate or the family or whatever else. Those can be really helpful. You want to think though about, is that an option that then the company and the other owners have, or is that an obligation that they have where they must do that? Similarly, upon there's been a bankruptcy, or sometimes if somebody gets fired or quits working for the company, and that's really while they were there, it can trigger those rights. So be thinking about those. I think that is our presentation, folks. Happy to answer any and all questions you've got. I'm happy to tell more dad jokes, but please don't make me do that to everyone right now.
I'm not seeing any questions so far.
Good. Go back to our, there we go. Mike, did you say you saw a question from Bueller? Bueller? I know. I did say no dad jokes, but I couldn't help myself. Yeah.
Yeah, I think we're good to go. I'm not seeing any questions. Thank you guys so much for taking time out of your day to do this.
We can give it another moment or two if you'd like, Mindy, for any questions. And certainly folks are welcome to reach out to us if they've got any follow-up questions after the presentation today. Flamingo Inc., you are welcome.
All right, I think we're probably good. I don't see any questions in the Q&A or in the chat.
Great. Well, thank you all for your attention. Really appreciate it. Feel free to reach out to us with any follow-up questions. And Marcia and Mindy, thank you so much for taking the time to let us talk about this topic.
Thank you.
Thanks. Have a good one.
Thank you.
Bye.